This case troubles me, and I've been saying that for some time. Not all tragedies, and that is what this is, not all tragedies are crimes, and not all deaths, even at the hands of another person, are murder. Part of a prosecutor's job should not be asking the question of, can I prove a crime? But should I charge a crime? Deliberations continue in the closely watched trial of a military veteran accused of choking to death a homeless man behaving erratically on a New York subway. Plus, the longest-running criminal trial in Georgia state history finally comes to an end, and the results may shock you. And a woman convicted of killing her husband and leaving his body in a burn pile takes her last opportunity to speak in court to place the blame on her own son. All this and more this week on Courtroom Confidential. All right, folks, we are recording this on Thursday, December 5th of 2024. And of course, we are on verdict watch on one of our cases, many updates and others, so let's jump right in. First, jurors continue to deliberate the trial of a military veteran charged with using a fatal chokehold to subdue a New York subway rider whose behavior was alarming and threatening to other passengers. The jury is weighing manslaughter and criminally negligent homicide charges in the death of Jordan Neely, a troubled homeless man. Daniel Penny, a former Marine, has pleaded not guilty and maintains that his actions were a justified attempt to protect himself and his fellow subway riders. Since deliberations began, the jury has sent 7 different notes to the judge requesting key pieces of evidence. Among the evidence requested are transcripts from testimony from some of the 40 witnesses who testified during the 7-week trial, and a cell phone video of Penny placing Neely in the chokehold for nearly 6 minutes. The jury also requested video of New York City police body cam footage, along with video of Penny's interviews and New York City police investigators. On Thursday, the jury sent a note to the judge requesting the definitions of recklessness and negligence and asked the judge to read each more than once. Part of the testimony the jury reheard Wednesday came from New York City medical examiner Dr. Cynthia Harris, who testified that the autopsy report and video shot by bystanders and investigative reports provided her all the information she needed to reach the conclusion she did in determining the cause of Neely's death. Quote, "No toxicological result imaginable was going to change my mind," Harris said, "even if they showed, quote, enough fentanyl to put down an elephant. No verdict has been reached as of the time we are recording this episode." What's happening here? Well, the favorite pastime of any trial attorney is trying to read the tea leaves of jury questions. So first we have them asking a question in regards to recklessness and negligence. And I think it would be sound logic to say that anytime jurors are trying to get the definitions of the law for the elements, they are probably leaning towards finding how the facts fit into those elements and therefore leaning towards perhaps a prosecution verdict. But who knows? On the other hand, they are also asking to have reread for them the testimony of this medical examiner who made this ridiculous statement that no amount of drugs, nothing in Neely's system would have any influence on her conclusions in this case. Putting that aside for a moment, and I'm going to come back to that because I've got a real problem with that. But just the fact that the jurors are asking for this testimony to be reread, a point that was seen as a strong point for the defense, you might be thinking to yourself, they're trying to convince other jurors who might have be on the fence that this is a rush to judgment on the part of the prosecution, and therefore they're leaning towards an acquittal. But who knows? End of the day, all that we know is that they are working, and that is a good thing. I will also say this. By the time we are releasing this episode, it will be Friday. And whatever it is about the cosmos, juries seem to love Friday verdicts. I think there's probably some logic in the idea that they want to enter the weekend knowing that they've put the job behind them. So I expect that by the time you are listening to this, we may be talking about a verdict. If this slips into the weekend and into next week, then I think discussions about a deadlock jury might be more appropriate. But at this point, they're working And that's all we know. If we had silence from them, that might be a problem. But they're asking questions. They're asking for readback. They're asking for evidence. They're doing their job. Maybe there are just some jurors back there who need a little more convincing either way. But let's get back to this medical examiner. The experts and medical examiners are supposed to have no dog in the fight. Okay, they are supposed to be objective scientists. They may be often called by the prosecution to testify, and that's because usually the prosecution is going off of some conclusion that they made in arriving at whether or not to bring charges. If the medical examiner arrived at the conclusion this was a homicide, that usually influences the prosecutor's decision to bring murder charges, and therefore they're going to call the medical examiner to explain those conclusions. But they are supposed to be objective scientists. They're not on the team of the prosecution. They're on the team of science and objectivity. And to make a statement that toxicology would have zero influence, that he could have enough drugs in his system to put down an elephant and that wouldn't change my mind, does that sound like science and objectivity to you? To me, that sounds like someone who's completely dug in. It's a ridiculous statement. I don't care how you square this entire trial. That is a ridiculous statement to be heard coming from a scientist. Usually, in my experience, these experts are very reluctant to weigh in with their own kind of feelings and opinions on a case. They will give you answers such as, the evidence suggests, or I was not able to exclude the conclusion that such and such. But this idea that I don't care what you put in front of me, it wasn't going to change my mind. I'm basing this off of a video and an autopsy. And if that man had enough opium or enough fentanyl in his system to put down an elephant, that wouldn't change my mind. How ridiculous and how problematic for the prosecution, and how interesting that the jurors are asking about it. This case troubles me. And I've been saying that for some time. Not all tragedies, and that is what this is. Not all tragedies are crimes. And not all deaths, even at the hands of another person, are murder. Part of a prosecutor's job should not be asking the question of, can I prove a crime? But should I charge a crime here? They are gatekeepers. You would hope that they would take a breath and realize that just simply because I can squeeze the facts of this case into the elements of a crime, therefore I should try to prove it. In my view, that's not how things should work. But what do you guys think? This is a case that has heavily divided a lot of people who have been watching it. What do you think? Is Daniel Penny a hero or is he a murderer? Please let us know in the comments. The long-running gang and racketeering trial that led Atlanta rapper Young Thug to plead guilty in October ended on Tuesday with the last two defendants found not guilty of racketeering, murder, and gang-related charges. Diamante Kendrick, known as Yak Gotti, was acquitted of all charges, and Shannon Stillwell was found guilty only of gun possession. The verdicts came nearly 2 years after jury selection began and a year after opening statements, in a trial plagued with problems. The original sweeping indictment charged 28 people with conspiring to violate Georgia's Racketeer, Influenced, and Corrupt Organizations Act. Young Thug, a Grammy-winning artist whose real name is Jeffrey Williams, was set free on probation after he pleaded guilty in October to gang, drug, and gun charges. Tuesday's verdicts mark a major setback for Fulton County District Attorney Fani Willis. Critics had criticized her use of the state's anti-racketeering law in an unwieldy case that saw multiple missteps and delays, including the recusal of a judge midway through trial. Defense attorneys maintained the state relied on faulty evidence, song lyrics, cherry-picked social media posts, and unreliable witness testimony to create a misleading narrative about young men who turned to music to escape economic hardship and difficult paths. What's happening here? What an absolute joke. Usually I try to stay out of discussions that talk about the use of public resources in the pursuit of justice and whether or not a district attorney should bring charges and consider the amount of public funds being spent on that. I don't think that prosecutors, by and large, should be thinking about money they should be thinking about doing the right thing. And if doing the right thing happens to cost a lot of money, then so be it. But in this instance, I think they got it all wrong. Not only did they bring an overwrought, overcomplicated, and overcharged case, not only did they waste thousands of hours, resources, and not to mention the jurors' time for 2 years. End of the day, they couldn't even bring a conviction. I mean, are you kidding me? Now I'm going to start talking about wasted resources. Now I'm going to start talking about taxpayer money. When you took 2 years of your prosecutor's time, the resources spent for defense attorneys, some of those perhaps supplied by the state, the jurors, everyone involved in this entire case. And what you ended up with was an unmitigated dumpster fire. What an absolute embarrassment. I really do not see how the DA survives this. This whole thing screamed to me of some sort of ego campaign from the very beginning, from everything that we heard about how many people were charged, the use of a RICO statute, the use of rap lyrics, everything about it. But the one saving grace could have been, at the end of all of that, you secure convictions. And then you can stand in front of an array of microphones and say, you know what? The jurors understood what we were trying to do, and the jurors understood the evidence, and that's why we secured these convictions. But you don't even have that. All of this, and the only thing the jurors gave to you at the end of the day was a felon in possession of a firearm charge. You know how quickly a felon in possession of a firearm trial can take place? We used to do those in an afternoon. Jury selection took longer than the presentation of evidence. 2 years, wasted time. And this goes towards the point I was trying to make in the previous case as well. Prosecutors are gatekeepers. Aside from some very rare circumstances, there are very little checks on what a prosecutor can bring as far as charges. So we entrust them to do justice, to do the right thing, not merely to try to get convictions. They're the ones making the call. There's no one stopping them, for the most part, from bringing charges against someone and putting them, in this case, through 2 years of misery to end up with absolute zilch. Prosecutors have a very unique job. Defense attorneys are just supposed to defend their client. They're supposed to advocate zealously on behalf of their client. That's their one mission. Prosecutors have to wear 2 hats, because not only are they supposed to be trying to put criminals away, but they should also be using discretion for when not to pursue a case. And only they can make that decision. They represent all of us. And in this case, I think they failed miserably. But what do you guys think? What do you think of the results? 2 years later, and 1 jury conviction to speak of on a gun charge that could have been handled in an afternoon. Please let us know in the comments. The wife of a prominent Atlanta attorney who was found guilty of killing her husband and burning his body will spend at least 30 years behind bars. Last month, the jury convicted Melody Farris for the murder of her husband, Gary Farris, at their Cherokee County home in 2018. The jury deliberated for 4 days. On Thursday, Judge David Cannon sentenced Farris to life in prison with the possibility of parole after serving a minimum of 30 years of her sentence. During the trial, it was revealed that Farris had an affair in 2009, which reportedly caused a breakdown in the marriage that was never fully repaired. Around the time of the 2018 murder, the couple was reportedly arguing about finances. The couple's 3 children, Emily, Chris, and Scott, testified during the trial. During the sentencing, Farris told the court that she had waited over 6 years to tell the truth. She claimed she wanted the world to know who killed her husband, asserting that not only did she not kill him, but that the perpetrator was her son, Scott. We have some courtroom footage of that to show you now.
Not only did I not do this, I know who did. I know Scott killed his father. He took my husband, the father of Chris, Emily, and Amanda. He took Big Daddy from our grandchildren, Ella, Addison, Olivia, Jax, and James, 3 of them who never got to know Gary. Scott, this is unforgivable.
Farris went on to describe actions Scott reportedly took after the murder to cover up the truth, claiming he had anger issues and failed a polygraph test. However, Judge Cannon eventually interrupted Farris, instructing her to focus on why the court should show her leniency and not to bring up matters that were not entered into evidence during the trial. In addition to the 30-year minimum, Farris was also sentenced to 5 years for concealing the death of another and 5 years for false statements. The sentences for those counts will run concurrently. What's happening here? I don't have a whole bunch to add here, other than the observation, which continues to amaze me, that perhaps more often than it should be used statement, that truth is stranger than fiction. This is real life drama being played out in front of us every day. And I think it's important for us to remind ourselves of that we shouldn't become spectators of all of this, that this is real people and real drama and real lives being played out in front of us. This is a real narcissist clinging to the very bitter end to the idea that she is an innocent, falsely accused person. Or are we watching an innocent person telling us who the real killer is? And that is kind of the point. This isn't TV. This won't all be wrapped up neatly in next week's episode. We get to see these things happen in court about real people, that she is going to serve a real 30 years in prison. Every once in a while, you find a case or a moment that takes place in court that kind of reminds you of that. And I think we do ourselves good to reflect on that. But what do you guys think? Was she rightfully convicted, or was this a huge miscarriage of justice? Let us know in the comments. Hey guys, before we jump into the other cases making headlines next week, I wanted to take a moment to ask you to please do me one very small favor, and that is, if you haven't already, please subscribe to this channel. We are blown away. We just surpassed 15,000 subscribers, and we want to continue to provide you with more and more content every week. And the way that we can best do that is through your support. So please subscribe now. And don't forget to check out Courtroom Confidential as a podcast. Join our community on all major podcast platforms. A Florida woman was sentenced Monday to life in prison for zipping her boyfriend into a suitcase and leaving him to die of suffocation amid a history of domestic and alcohol abuse. Judge Michael Kranick imposed the sentence in Orlando on Sarah Boone for the 2020 killing of 42-year-old George Torres. In her own statement, Boone went through a litany of abuses by Torres she claimed to have suffered over many years, decried the way her trial was handled and covered by the media, yet asked for forgiveness for her actions. Quote, "I forgive myself for falling in love with a monster. I tried breaking the spell. I never stopped loving him," said Boone, who has been in jail for 58 months. "I didn't mean for this to happen. Forgive me, George. Forgive me, Torres family." At first, Boone told investigators that she and Torres had been playing hide and seek on February 23rd, 2020 in their Winter Park residence when they thought it would be amusing for the 103-pound Torres to climb into the suitcase. They had been drinking alcohol and she decided to go to sleep. When she woke up the next morning, she unzipped the suitcase and found Torres unresponsive. Boone was charged with second-degree murder after investigators found videos on her cell phone in which Torres is heard yelling from inside the suitcase that he couldn't breathe and repeatedly calling out Boone's name. "Yeah, that's what you do when you choke me," Boone said in one of the cell phone videos from that night. "Oh, that's what I feel like when you cheat on me." Boone previously rejected a plea offer from prosecutors that would have imposed a 15-year prison sentence in exchange for her guilty plea to a reduced manslaughter charge. A Southern Carolina woman who admitted to drinking and was driving well over twice the speed limit when she smashed into a golf cart, killing a bride who had just got married, was sentenced Monday to 25 years in prison. Jamie Lee Komoroski pleaded guilty at the Charleston County Courthouse to reckless homicide, felony DUI causing death, and 2 counts of felony DUI causing great bodily injury before her sentencing. Police allege Komoroski drank at several bars on April 28, 2023, and was driving 65 miles an hour on a narrow beach road with a speed limit of 25 miles per hour when she slammed into the golf cart, leaving a wedding. Her blood alcohol level was 0.26, 3 times the legal limit to drive. The 34-year-old bride, Samantha Miller, died while wearing her wedding dress. The groom, Eric Hutchinson, suffered a brain injury and numerous broken bones. The cart was thrown 100 yards by the crash. Hutchinson told the court, "On the golf cart, she told me she didn't want the night to end, and I kissed her on the forehead. And then the next thing I remember is waking up in the hospital." Komoroski was sentenced to the maximum of 25 years in prison for felony DUI causing death by Judge Deidre Jefferson. She also was sentenced to 15 years in prison for each count of felony DUI causing great bodily injury and 10 years for reckless homicide to run concurrently. A former Florida ballerina has been sentenced to 20 years in prison following her manslaughter conviction for fatally shooting her estranged husband in 2020. Judge Matt White imposed the sentence Tuesday on Ashley Benefield after rejecting her request for a new trial based on allegations of juror misconduct. Benefield contended she killed her estranged husband, Doug Benefield, in self-defense during an argument at her house in Bradenton, Florida, about 30 miles south of Tampa. Benefield had been charged with second-degree murder, but the jurors opted for a lesser manslaughter offense after nearly 7 hours of deliberations in July. The maximum sentence for that crime is 30 years behind bars when a firearm is used, while the murder charge carries a potential life prison term. Before the sentencing, White rejected defense motions for a new trial based on claims a juror failed to disclose a personal history involving domestic violence and that one juror improperly brought a cell phone to the jury room during deliberations, which the judge found had no merit. Benefield's attorney has said she will appeal the conviction and sentence. A judge has denied requests from prosecutors to obtain phone records from the parents of a Massachusetts woman for a month before and including the night that she allegedly struck her boyfriend, a Boston police officer, with her SUV and left him for dead in Canton in 2022. In brief rulings denying motions for the phone records of Bill and Janet Reed, the parents of defendant Karen Reed, Judge Beverly Cannoni wrote, quote, "Despite the detailed arguments articulated in the supporting memorandum and at oral argument, the affidavit in support of the motion is insufficient on its face and fails to meet the requirements of state law." The ruling was followed by a motion filed Tuesday this week where prosecutors took aim at Dr. Marie Russell, a retired emergency room doctor in California, who testified for the defense at Reed's first trial for the murder of John O'Keefe. Special prosecutor Hank Brennan is asking Judge Cannoni to bar the defense expert from testifying at the retrial, saying the retired physician wasn't qualified to offer an opinion that dog bites were responsible for the wounds on O'Keefe's arm. Reed's first trial ended in a mistrial after the jury failed to reach a verdict. Her next trial is scheduled to begin January 27th of 2025, but both sides have asked the court to delay until April. No decision on the start date has yet been issued. An October trial date has been set for a Massachusetts man charged with killing his wife and then disposing of her still unlocated body. Assistant District Attorney Gregory Connor said prosecutors are still waiting for DNA testing of material seized in January 2023 from the home of Brian Walshe and a hacksaw recovered from a dumpster outside an apartment complex where Brian Walsh's mother lived. Walshe is charged with killing his wife, Anna, inside their Cohasset home on New Year's Day 2023, dismembering her body and disposing of her remains in several locations around the state. Anna Walshe, a real estate executive who worked in Washington, D.C. and split her time between there and Massachusetts, was reported missing by coworkers on January 4th. On New Year's Eve of 2022, the Walshes had hosted a dinner party at their home. By 4:50 a.m., authorities allege Anna Walshe was dead, and her husband had used his son's iPad to conduct searches such as how long before a body starts to smell and how long for someone to be missing to inheritance. Walsh's lawyers have raised questions about the integrity of the investigation, noting that the lead investigator was Massachusetts State Trooper Michael Proctor, who was suspended without pay after he was lambasted by the defense during Karen Reed's murder trial last summer, as crude and misogynist texts he sent to friends about her were revealed in court. The judge set trial to begin October 20th of 2025. To get up to speed on this case, please check out our case notes episode that we did on the Brian Walshe murder case. The link is in the description below. New attorneys for the mother of Oxford High School shooter Ethan Crumbley filed a motion on Monday for an acquittal and new trial, arguing that Jennifer Crumbley's criminal trial in connection with the November 2021 shooting was, quote, tainted from top to bottom. In a first-of-its-kind case, a Michigan jury in February convicted Jennifer on 4 counts of involuntary manslaughter for the shooting her son carried out on November 30th of 2021, killing 4 students and injuring 7 others. Her husband, James Crumbley, was later convicted on the same charges, setting a new precedent for parents of children who commit crimes. Through her attorneys, Crumbley alleged that she was the target of an overreaching prosecution that made numerous missteps, including deliberately withholding evidence from her about secret deals it made with school witnesses who testified against her. According to the motion, 2 school officials who drew scrutiny over their decisions involving the shooter had signed confidential proffer agreements that protected them from having anything they told investigators used against them. Those agreements, however, were never made known to the defendants or the jury. Oakland County Chief Assistant Prosecutor David Williams responded to the allegations saying, quote, no witnesses were given anything for their testimony and there was no immunity. These witnesses testified without promises or protection whatsoever. No hearing date has been set on this latest motion. Before we jump into what's on the docket for next week, I just want to take a moment to thank you all for your support. The love from our growing community has been absolutely amazing. But I want to give a special shout out to Lolo in the 440 for their glowing review on Apple Podcasts, and to our members, Simi Sharp and Catherine Regier, for their kind words on YouTube. Please keep them coming, folks. We highly appreciate your feedback. On the docket next week, 74-year-old Miami woman Donna Adelson is set to appear at a case management hearing on December 10th. Adelson is the 5th person to face charges in the murder for hire of Dan Markell, her former son-in-law. Markell was fatally shot in his garage of his home amid a bitter legal battle with his ex-wife, Wendy Adelson, who is Donna Adelson's daughter. Utah woman Kouri Richins will be back in court on December 12th for a hearing ahead of her trial for aggravated murder for allegedly poisoning her husband, Eric Richins. Prosecutors claim Eric was poisoned by a cocktail provided to him by Kouri, laced with a lethal dose of fentanyl. And finally, please check out the latest episode in our Courtroom Confidential Conversation series this coming Monday, when we sat down with Andrea Burkhart. That is set to premiere on Monday, December 9th at 5 p.m. Pacific, 8 p.m. Eastern. We would love to see you in the chat. That is it for us this week, folks. I am your host, Josh Ritter. You can find me on all social media at Joshua Ritter ESQ or at joshuaritter.com. Thank you again for joining me. Have a great weekend, and I'll see you again next week for another episode of Courtroom Confidential.